Hello, and welcome to Williams Mullins Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today I'll be joined by my colleague, Courtney Reigel, an associate in our intellectual property practice group here at Williams Mullins, to discuss updates at the United States Copyright Office regarding copyright small claims and the Copyright Claims Board. Courtney, how are you today?
Thanks, Janet. I'm doing well. You may have recalled hearing a few years ago that Congress passed the Copyright Alternative in Small Claims Enforcement Act of 2020, or the CASE Act, and some of our listeners might be familiar with the passage of that act as well, which directed the Copyright Office to establish the Copyright Claims Board, or the CCB. The CCB is a 3-member board within the Copyright Office that will provide, in the Copyright Office's words, an efficient and user-friendly option to resolve copyright disputes that involve $30,000 or less. Under the Act, claims under this amount are referred to as small claims. The Copyright Office set spring of 2022, so right now, as the time frame for when the CCB would begin hearing small claims disputes. The CCB is not up and running yet, but the Copyright Office has recently issued several final rules regarding the small claims process. This includes an overview of the procedures for the CCB, filing fees, and other details about the small claims process, and has committed to receiving claims by June 25th, 2022. Today, I thought we could highlight a few key points of the CASE Act and updates from some of the Copyright Office's rulemaking efforts in light of the imminent commencement of small claims being heard by the CCB.
Courtney, that sounds very interesting, and I know you and I were always interested in knowing about innovations and new developments in intellectual property, and this is right in line with that. I do remember hearing about the CASE Act being passed and some changes coming to the Copyright Office. I think it would be helpful to share with the listeners of our podcast some highlights of the CCB and what users or potential users can expect in the very near future.
Thanks, Janet. I agree. And those of you who are somewhat familiar with copyright law and the CASE Act may know that the CCB and the small claims process has actually been a long time coming. However, listeners that are maybe not as familiar with copyright law might benefit on just a few notes about the history of the CASE Act. So we'll start there. So you must bring a copyright infringement lawsuit in federal court, and you must have a copyright registration and not just a pending application to file suit. As a result, there are some barriers to copyright litigation, and it can require a lot of time and money. Sometimes, and I'm sure many of us have actually been in a situation discussing this with a client, the expense and effort of a federal lawsuit can outweigh the potential relief. For a number of years, the Copyright Office has been developing an alternative forum to federal court for small copyright disputes, which resulted in the passage of the CASE Act and establishment of the CCB. The goal of the CCB is to provide a faster, lower-cost option for bringing copyright disputes, but the damages available will be limited to $30,000. However, participation in a proceeding before the CCB is actually voluntary, which is an interesting detail, and there are a few other interesting details about the small claims process that I will get to in a moment.
That's really helpful, Courtney, and I think these institutions that help manage legal fees and disputes or providing alternatives to court litigation, I think are always helpful and expand accessibility to legal relief to people who might not otherwise have it. So are we going to hear a bit more on the mechanics of the CCB and the small claims process?
Yes, yeah, Janet, I agree. And I'll provide a few details about the process. And in doing so, I'll also highlight several key differences between disputes before the CCB and typical copyright litigation in federal court. So first, one of the big differences is that while the CCB is physically located in Washington, D.C., that proceedings will be handled completely electronically and remotely. So no need for parties to travel, which already brings down the cost quite a bit. With a few exceptions, all filings will be submitted through an online filing system called eCCB. Claimants will initiate a claim using an online form, which will have several prompts that you include basic information like the type of claim being asserted, the copyright protected work at issue, and other details regarding the dispute. Essentially, the Copyright Office is trying to make this process easy to navigate for claimants without counsel and who may not have a legal background. Once a claimant files a claim, it will be reviewed by a CCB staff attorney for compliance. And if the claim is compliant, the CCB will notify the claimant and provide instructions on how the claimant can proceed with sending the claim to the other party or parties in order to formally serve notice. Interestingly, you do not need a copyright registration to file a claim with the CCB, which is a prerequisite for filing suit in federal court. You do need to have at least submitted an application, though. So if you do not already have a copyright registration, you can apply, or you can simultaneously file an application at the same time that you file a claim with the CCB. If the claimant's copyright application is later refused, the CCB will dismiss the claim without prejudice. As is the case in federal court, a statute of limitations will exist for filing a claim with the CCB, which will be 3 years from when the infringing activity took place. And as I briefly mentioned before, while the CCB is a streamlined alternative to federal court, it is a voluntary option. So both parties must agree to participate in a CCB proceeding. So if you are served with an initial notice from a claimant notifying you that you are a defendant, called a respondent in a CCB proceeding, you have 60 days to decide whether to participate or to opt out of the proceeding. Respondents can opt out at any time during those 60 days, and they do not have to provide any reason for their decision to opt out. If you decide to opt out, the CCB will dismiss the claim against you, but the claimant can still bring the claim in federal court. But if both parties do decide to participate and the CCB decides a case, then the same claim cannot then also be filed in federal court. So you have to pick one or the other, CCB or federal court. And pretty much all parts of a CCB proceeding will be streamlined, including the discovery process and discovery obligations. So unlike in federal court, in a CCB proceeding, the parties are only going to be required to exchange limited key documents and information, and everything, as I mentioned before, including hearings and conferences, will be held virtually. While you do not need an attorney to file or defend a claim with the CCB, you can have one if you'd like. And another interesting provision under one of the final rules issued by the Copyright Office is that you may actually have a law student represent you pro bono in a CCB proceeding. I also wanted to point out that the CCB will be able to consider not just claims of copyright infringement, but also claims for a declaration of non-infringement or declarative relief, as well as certain claims under the Digital Millennium Copyright Act, or DMCA, and counterclaims and defenses for the same. In terms of filing fees, there are 2 separate fees that CCB claimants will be required to pay. There's a $40 filing fee at the time of the initial filing, and then a $60 fee once the proceeding becomes active, which means that the parties haven't opted out after the 60-day opt-out period ends. So obviously, those expenses are considerably less than federal court litigation. So the CCB is likely going to be an attractive forum for pursuing small claims based on these very low filing fees, the fact that you can participate electronically, and just that the barrier to entry is significantly less than federal litigation.
Thank you, Courtney. That was a really detailed and helpful explanation of the CCB procedure. And I agree, between the lower filing fees and the change in the obligation of having a registration at the time that a claim of the CCB needs to be filed, and then the virtual proceeding, I think there's a lot that's being done to help manage or mitigate legal costs for petitioners and respondents in these kinds of proceedings. So thank you for sharing. So in addition to the procedure that you shared, can you talk a little bit more about the type of relief that's available in CCB proceedings?
Of course, Janet. As we've mentioned, the small copyright claims that the CCB will hear involve relatively low amounts of money. In federal court, actual damages and profits in copyright cases do not necessarily have an upper limit, and statutory damages can be as high as $150,000 per worked infringe. So that's quite a bit of money, but alternatively, small copyright claims that can be brought before the CCB cannot seek more than $30,000 in total damages. and any statutory damages are limited to $15,000 per work infringed. A party who brings a successful copyright infringement claim can choose to recover either statutory damage or actual damages and profits. However, the CCB cannot issue injunctions, and successful parties can only recover attorney's fees and costs in exceptional circumstances if the other party has acted in bad faith. Listeners may also be wondering what happens if a party does not opt out of a proceeding, but just does not respond. So if a party does not respond in a proceeding and has not opted out, the CCB may enter a default determination against that party. So it is important to respond or opt out of these proceedings if you receive an initial complaint from a claimant. If the CCB decides that a party is in default, it can dismiss their claims or counterclaims and order them to pay monetary damages. Finally, I will mention that there is even a more streamlined process for claims of $5,000 or less, which the CCB is calling the smaller claims procedure. Smaller claims will be decided by a single copyright claims officer instead of three, but determination will have the same effect as one issued by the full CCB. To wrap things up, I just will mention that I'm very interested to see how these claims before the CCB are going to play out. I'm also interested to see whether respondents typically opt out or choose to engage in these proceedings. The CCB may not be the best option for complex cases. For example, if cases involve very complicated facts or evidence beyond what is included in the limited discovery that occurs in a CCB proceeding, it may not be the best forum. But pretty soon, copyright owners will need to undertake a cost-benefit analysis to determine whether to pursue a CCB claim or to instead stick with traditional federal litigation. Entities and individuals who receive a notice that the CCB claim has been initiated against them will also likely be seeking legal advice on whether to engage as a respondent in the CCB proceeding or to opt out.
Courtney, thank you for sharing that information. And I agree that the CCB may not be the right venue or the right type of proceeding for every claimant, but I do think it's a positive development that there is this option for small and smaller claims, because I think there's always a need for trying to find a resolution short of court litigation, especially when the costs can be so high. So thank you so much for sharing. And that will wrap up our discussion on small claims and the Copyright Claims Board. I'd like to thank Courtney for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.